economic and political power is a much better security for world stability and peace than regressing into bilateralism. Therefore, in order to ensure that globalization does not lose its appeal, the discontents with globalization have to be minimized. A more equitable, a more just, and apparently fair formula for burden sharing and for dispersal of global resources has to be worked out. Not what that formula would be, how it will be worked out is not clear to me, and neither is it my remit. But I have no doubt in the ingenuity of the global leadership to find such a common ground. It can be done. But to the extent that there is now discontent with globalization for various reasons is a very serious development and is a very fearsome development as far as I'm concerned. I think we'll be regressing back into isolationism, which, thanks to technology and the preponement of the 21st century on account of technology and globalization, would cause would have disastrous consequences for the evolution of a more equitable world order. Globalization is the way forward. I have no doubt in my mind. How to make it work, how to remove its disparities and inequities is at the heart of your question. And I think it's well taken, but somebody will have to find a way, and it can be done.
Why not?
Thanks. My name is Orijit. I work for Amnesty International. Cheryl, you mentioned that 7 Rohingyas were deported and they were taken out of jails in Assam overnight. And what we hear that they have been reunited with their family, they've been given NVC card. And also there are some reports that have come out that there are 20 more Rohingyas who've been identified, again in jails in Assam. And there's a high chance that they might also be expelled. So my question is that the decision of the Supreme Court, do you think that it sets an uncomfortable tone and tenor politically once the final NRC list comes out in January or whenever it comes out? Mr. Bhushan, you can also take.
Yeah. You see, that order of the Supreme Court is premised on this affidavit of the government saying that these people indeed want to go back. The mistake that the Supreme Court made there, in my view, we said that please verify this, send the UN High Commissioner for Refugees to verifying whether they indeed voluntarily, whether this is informed consent or not. And they said that no need for that, and they quickly passed the order virtually allowing their deportation. Now, this is not likely to be a precedent for such future orders in the case of other Rohingyas which might come up in future.
But what his question is whether the other 20 are also in detention. So has the deportation of these 7 set a precedent for further deportations of those Rohingya who are in detention centers in Assam?
And also politically, does it set a very uncomfortable sort of
so
idea?
it will depend upon whether the government again says that they have given consent. See, one fact which we found was false in the government's affidavit. We have not been able to verify whether they had indeed given their consent or not. Because apparently after they went back to Myanmar, despite efforts by various organizations to meet these people and find out what really happened, nobody has been able to meet them. No outside agency has been able to meet them. They have been virtually kept in isolation by the Myanmar government. It seems that this was one of the things that Mr. Modi probably worked out with the Myanmar government during his visit to Myanmar, that these people would be taken back, but they would not be allowed access to anybody outside, whether any international agency or otherwise. When it comes to other cases of this kind, probably, hopefully, the Supreme Court is likely to be more careful, given the fact that the government did make one false statement about their citizenship. They will be more careful, and hopefully this time they will send somebody to verify whether there is informed consent or not. I don't readily subscribe to the view that that first case of 7 people would serve as a precedent for all such future cases, even if those people are really in detention and a similar kind of thing is done by the government.
Just on the 20, which the government has said that they're going to be verifying, the difference there is that they are actually registered refugees and UNHCR has access to them. They're registered asylum seekers. So in that sense, with the 7, the difference was that they had never approached UNHCR, so the government still had a argument to say that they had never tried to access asylum, and therefore they just illegally entered the country, and they never asked for protection because they never had access, practically speaking. But theoretically, they still had that argument, and the government supposedly had them sign consent forms. With the 20, however, we do have access. We do have access through UNHCR and its partners. And I believe that some of them have been, like, their initial sentence was 3 months, but they've been in detention for 8-9 years now. And out of that, majority are actually children who are there. So, and the conditions in the prison are really bad, so they are happy to just sign whatever and return. If that happens, it's a tricky legal issue because technically they had tried to access asylum, and the Guwahati High Court denied that. They even went to court, and then the court basically asked the MHA to respond to this, and then nothing came out of it. And meanwhile, this deportation order came, so the Guwahati High Court said, no, you can't access UNHCR anymore. So it's going to be very tricky. So we're all watching what's going to happen with the next round. Yes.
Good morning. My name is Aditya Farnekar. Who? Yeah, so I'm Vignesh. I'm a student of National Law School. So my question is to Professor Barao. So this is just a purely academic question relating to the principle of refoulement. So if you know that it comes from Article 33 of the Refugee Convention. So if you look at Article 33 has envisaged certain exceptions under the principle of refoulement. But when you consider the refoulement itself as jus cogens, so how do you exactly bring these exceptions into perspective? So do these exceptions no longer exist because of the fact that it's been recognized as jus cogens, or so in that case, what other recourse do the states have in terms of a legitimate security threat or something like that? So.
I don't think it has been recognized as a norm of non-reformer as a norm of jus cogens. I mean, that is a contested one. The whole idea of norm of jus cogens is limited to very few, and what constitutes in it is a contested one. It is a general understanding that there are certain issues which have attained the status of norm of jus cogens under international law, like genocide, torture, prohibition of torture, prohibition of genocide. But the exceptions, if a norm reaches a particular stage, along with that, it also goes with exceptions, a part of it, like whether it applies to the question of customary international law or norm of jus cogens, because what becomes a norm of jus cogens or customary international law, if one has to identify it, probably it might also include the question of exceptions into it. So that is not devoid of it, and it's not an absolute one whenever it reaches a particular stage. So in that sense, even if it comes along with that, assuming that even a customary international law part of it, but exceptions are part of it. So therefore, it's not an outside the legal framework of it. So there is nothing called an absolute status.
In any case, you see, if it is a security issue in terms of somebody coming in as a refugee who is a terrorist or who is a known terrorist, etc., or who's reasonably apprehended to be a terrorist, then the government can certainly put him in prison immediately after he is given asylum. So therefore, security issues are no answer to the principle of non-refoulement. principle of non-refoulement is absolute. Even a terrorist seeking asylum here, if he is likely to be killed there for non-legal reasons, if he is likely to be put to extrajudicial death in that country, is entitled to seek asylum here. But after having been given asylum, the government is entitled to put him in prison immediately under any domestic law.
I just wanted to add to that, Article 33 has the principle of non-refoulement, and the exception to that is in Article 33(2), which says that non-refoulement can be invoked, only this mass refoulement can be invoked in very specific cases. And even in those cases, it requires a very individualized and a specific threat assessment. So it is on an individual basis. Mass refoulement is anyway arbitrary and illegal, and it can't be permitted.
With the Rohingyas, there's not been, I mean, that's one of the things which we came up in court, which is that there's not yet been a single incident of, or like an FIR also filed against any of them saying that they have committed a criminal act.
Petty criminal maybe, but nothing serious in terms of...
Yeah. So it says, in fact, the answer in the Legislative Assembly in J&K, it says, no Rohingya refugee has been found involved in militancy-related incidents. And again, the BSF director says, no Rohingya apprehended by them were found to have any links to any terrorist organizations. These are all in response to the government's claims that they are terrorists and they are a national security threat and they're involved in militancy. And
Can we have a question from you?
Dr. Bora, you said that in the Bangkok principles, even though they're non-binding, the refugee convention was sort of modified to suit the needs of Asian countries. But later you said that one of the reasons why India hasn't signed the 51 convention is because it addresses the concerns of, it does not address the concern of developing nations like India accurately. So then if that's the situation, then what's the purpose of the Bangkok Declaration? Like, was it not effective?
If I got your question correctly, no, the problem with the 51 convention is, one issue is the definition part of it. Like it specifically on those specific 5 grounds, there has to be well-founded fear of persecution. But there is also a possibility that for internal conflicts, which is the reason for a mass movement of people, where there you might not feel undergo the fear of persecution, but at a general level of violence happens, people move. In a if you go by 51 convention, that might not satisfy the requirement of to grant the refugee status. So these are one of the issues. That is one of the issues along with the Bangkok principle addresses that. They included that as part of the principles, and the same is the case with regard to the burden sharing part of it. So the problem with the convention is on some of these, which they try to address it in Bangkok principles, but not as a legally binding instrument, because it is just a principle. So there it does not, I mean, it's a kind of a regional organizations declaration without any binding obligation on any of the member states of ALCO.
So then the prime reason that India still hasn't accepted even though the Bangkok Declaration exists is because of the non-binding nature of it.
No, India is part of ALCO for the Bangkok principles.
The prime reason India hasn't ratified the 51 convention.
Yes, that is the 2 or 3 reasons that India, at least in a stated position, said about that is primarily it does not address the developing countries' concerns. Does not have the burden sharing one. It does not address the mass influx of movement of the people. So these are the concerns which India has at least proclaimed it, at least formally said that these are the issues on which.
Am I audible? Okay. So my first question, today's discussion was focused on Article 51, our international obligations. But what about Article 50? It's a policy matter, it's a diplomatic decision, and shouldn't we leave it to the executive? And shouldn't judiciary exercise certain restraint? Because these decisions would have consequences vis-a-vis international relations. To give an example, we accommodated Dalai Lama, And one of the reasons China used was for the war, 1962 war, was that, although it was one of the reasons, not the sole reason. So I just wanted to say that it has consequences with respect to international relationships. Isn't Indian government in a better position to take a call? Shouldn't it be? And suppose, talking about 1421, suppose Indian judiciary makes a declaration that we, because of our international obligations, have to accommodate refugees. And since we accommodated Sri Lankan refugees, we also have to accommodate Rohingyan refugees. So wouldn't that imply that, you know, the European countries are shutting their borders for the refugees? So wouldn't it make India an attractive destination for the refugees? In future, is it a possibility that India could become a refugee capital of the world? And if judiciary gives such a decision and Indian government is not given any choice, how would we deal with such a problem?
Literally summarize the arguments in the government's affidavit. Like literally that sentence was there, that we don't want to become the refugee capital of the world. Did you read it? Yes. You read that? Okay, fine. So will you?
Well, look, the answer is quite clear. In this particular case, India is a signatory and has ratified international conventions, thereby, by virtue of exercising its executive function in foreign policy making and in entering into international treaties, it has accepted the principle of non-refoulement in at least 12 internationally binding covenants. So it only has now to live up to its international obligations. You are absolutely right that foreign policy matters are not within the domain of the courts, and it cannot be. It is a sovereign function of an elected government. An elected government must exercise its jurisdiction and its discretion in the best interest of improving relations with other countries and carrying forward on the global arena its internal policies. But here, the fact remains that even today, the state practice, that is what the government actually does, is in principle, it says that it accepts the principle of non-refoulement. In fact, in 2017, Mr. A.K. Rai, speaking at a convention in Geneva, said that nothing should be done to dilute the principle of reforma, but in court, they argue to the contrary. And on a more fundamental basis, as I had adverted to in my earlier comments, every court, every government is first and foremost bound by its own constitution. Our constitution reaffirms loudly and audibly for anybody who wants to hear that consistent with our civilizational principles of universalism and Vasudhaiva Kutumbakam, India has always treated the whole world as one community. Within that, of course, our priority is our own people, but the fundamental rights, the basic, non-negotiable, inalienable human rights of all people ought to be and are respected in India. That has been our stated policy, right from the time we became a free nation, right from the time we had our national charter. So I don't see any contradiction in what you are saying. You are right when you say that foreign policy is the exclusive domain of the executive. But in this particular case, that is not something that is coming in our way. We have declared as part of our foreign policy, we have accepted as part of our state practice, we have acted accordingly in entering into various international treaties and conventions to protect the human rights of people, including respect for the principle of non-refoulement. So there is no contradiction between what you've said.
Foreign policy of the government cannot trump Article 21. That's a constitutional right which has been granted to everybody. So if the government says that, well, our foreign policy is to execute all people in India who are from Pakistan, let's say. If in India there are any people from Pakistan, we will execute them. That can't be done. You can't have any foreign policy or any policy of any kind which is violative of fundamental rights.
You want to go? Okay, I'll take one and then come back.
question is actually for Ms. Shankar. So, do you think that the paradox in India's position on refugees, if any, has only surfaced with respect to the Rohingyas? Because at least at the international level, there seems to be a consistency because they didn't sign the Refugee Convention, like Professor Gura pointed out, because they thought that there's structural inequity towards developing countries. And even now, they have been involved actively with the GCR negotiations because they strive towards burden sharing. So then, is the paradox only limited to Rohingyas, or have there been previous instances where such paradox has manifested itself?
So I think there have been previous incidents, but they have been very specific, like with a group of supposed informers or from Myanmar who were kept in Andaman. There have been incidents where the government has felt that there is an issue of national security, whether it was justified or not. People have been deported, people have been kept in detention centers. But it has not been the rule. That those are like those exceptions, very rare exceptions. With the Rohingyas, yeah, it's a surprise, and like they said in the previous panel, it's an aberration, and we hope it is, and there is no such order later. But the order just seems absurd, and like many of the panelists have pointed out, it seems purely politically